breaking the United States Security and Exchange Commission CC may win against Ripple in XRP sales discovery requests. A response was submitted by the United States Securities and Exchange Commission SEC in response to the opposition expressed by the defendant Ripple regarding the provision of audited financial statements for 2 years, post-complaint contracts for the sale or transfer of XRP to non-employee counterparties, and specifics regarding the amount of XRP institutional sales proceeds received following the prosecution of the lawsuit. Ripple's response to the United States Securities and Exchange Commission, the United States Securities and Exchange Commission (SEC) has reportedly provided a response to further support its petition to compel, as stated in a court document that was delivered late on January 23. The plaintiff CC contends that its demands for discovery about remedies are not untimely, but rather procedurally appropriate. In addition, it contends that courts primarily take into account post-complaint circumstances when determining remedies for violations of securities law provisions. Furthermore, the Securities and Exchange Commission, SEC, is attempting to send as strong a message that violations of securities laws would be taken seriously by requesting penalties from Ripple. Neither a mini trial nor any other determination about the legality of post-complaint sales to institutions, including ODL customers, is being sought by this organization. Specifically, it contends that it is not required to do so to get an injunction that would prevent those transactions from continuing. Picture Ripple can claim that it plans to organize future ODL sales in such a way that they do not fall under the purview of the institutional sales category that is governed by the summary decision. The SEC, on the other hand, asserts that it ought to have the post-sale and post-summary judgment contract to examine Ripple's intentions and determine whether or not it is economically feasible for Ripple to arrange ODL sales in a compliant manner. It may not lead to a mini trial, but there is a lot at stake with this issue, said Bill Morgan, an attorney who supports the development of XRP. A broad injunction might do some damage to Ripple's online decentralized ledger business. I believe that a discovery order will be issued about these post-complaint contracts. Ripple has responded to the Securities and Exchange Commission (SEC) request for financial statements and discovery. According to Ripple's declaration, which was submitted by Carolyn DeCherry, the Securities and Exchange Commission failed to request discovery while the fact discovery process was still ongoing, and as a result, there is no valid reason for further discovery about post-complaint sales. In addition, the Securities and Exchange Commission has utilized all of its interrogatories in this particular matter. Carolyn DeCherry, who worked as a consultant for Ripple from 2015 to 2019, has come out with a declaration in response to the SEC's request. During her testimony, she stated that Ripple, through XRP ILLC, had entered into XRP direct sales contracts with 23 different counterparties between July 2017 and April 2020, as documented in Ripple's respective business records. Additionally, she asserted that the majority of XRP sales that took place between May 2020 and June 2023 were old transactions, which meant that the XRP was obtained directly from Ripple. Additionally, she stated that Ripple sold some XRP on centralized digital asset exchanges through market makers to unknown customers. In the case involving XRP that is being litigated between Ripple Labs, Inc. and the United States Securities and Exchange Commission, SEC, the regulatory body, has provided a comprehensive response to the Honorable Sarah Netburn, who is the United States Magistrate Judge for the Southern District of Connecticut. The SEC's pursuit of full discovery from Ripple has reached a crucial new level with the submission of this document, which bears the title Reply in Further Support of its Motion to Compel. This document has the potential to transform the dynamics of this high-profile case. SEC demands financial documents regarding the XRP lawsuit. In its response, the Securities and Exchange Commission (SEC) addresses Ripple's concerns on the SEC's demands for the release of audited financial statements covering 2 years, the disclosure of post-complaint institutional sales contracts, and responses to an interrogatory concerning pre-complaint institutional sales. Ripple's position, which referred to the SEC's motion as untimely and asserted that the material that was requested was irrelevant to the court's judgment on remedies, is destroyed in the submission that the SEC has made. Within its argumentation framework, the Securities and Exchange Commission (SEC) emphasizes the timeliness and procedural legitimacy of its discovery requests. It answers Ripple's allegation regarding the breadth of discovery, underlining the shifting nature of the action and referring specific court records to indicate the contemplation and eventual endorsement of prolonged discovery periods. Moreover, it emphasizes the fact that additional discovery periods are being considered. Detton, a lawyer who supports XRP, explains why Ethereum was given a free pass. Related reading, Judge Torres endorsed this approach. The Securities and Exchange Commission claimed, citing court filings that highlight the iterative and adaptive discovery process that has been a defining characteristic of the action. Whether or not Ripple's financial situation and its post-complaint institutional sales contracts are relevant is a central point of contention for the Securities and Exchange Commission to argue. To effectively bolster its position, the Securities and Exchange Commission SEC makes use of legal precedents. In particular, it refers to the cases SEC v. Rajaratnam to emphasize the significance of a defendant's wealth in deciding penalties. It was stated in the response provided by the Securities and Exchange Commission SEC that the Second Circuit explicitly rejected this argument, holding that in calculating the size of a penalty necessary to deter misconduct, the extent of a defendant's wealth is a relevant consideration in the process of deconstructing the implications of Ripple's post-complaint institutional sales contracts. The SEC's narrative highlights the strategic importance of these papers in shedding light on Ripple's plans about the selling of XRP. Not only does the Securities and Exchange Commission consider these contracts to be retrospective records, but it also considers them to be prospective indications that may indicate the probability of future regulatory violations. Ivory wins big. It says anticipated that US banks will adopt XRP for international payments in the document that was submitted by the Securities and Exchange Commission. See, it was stated that the discrete post-complaint contracts that the SEC seeks are probative evidence as to this argument. This statement implicitly indicated that these documents could reveal trends or intentions that may have an impact on future compliance or non-compliance with the orders of the court. Aims of the SEC, Ripple's core business attorney, Bill Morgan, who is in favor of XRP, has shared his thoughts on the SEC's strategic positioning through the use of his client. According to him, the Securities and Exchange Commission SEC needs to demonstrate to the judge that placing an order for the discovery of post-complaint contracts will not result in a mini trial about the status of post-contract sales, as Ripple contends. Regarding the legality of post-complaint sales to institutions, including UDLD clients, the Securities and Exchange Commission SEC has stated that it is not seeking a mini trial or any other determination. According to Morgan's observation, the company claims that it does not have to do so to win an injunction that would prevent those sales from continuing. Furthermore, the attorney believes that Ripple may argue in front of the court that it wants to organize future XRP sales, which were formally ordered in such a way that the company does not come within the scope of the summary judgment institutional sales category. The result is that Morgan anticipates that these files will not result in a mini trial. Yet, there is a great deal at stake about this matter. A broad injunction might do some damage to Ripple's online decentralized ledger business. I believe that a discovery order will be issued by the court on these post-complaint contracts.